Hi guys, it's David Campanile here, owner of Campanile Law, located in the great state of New Jersey. I'm here to talk to you today about the foundational documents of estate planning. As always, if you want to chat with me about estate planning, set up your own estate plan, you can contact me at njestateattorney.com. So let's just dive right into it. I know I've gone over in recent videos the documents, different documents such as a will, a power of attorney, a medical power of attorney, and a living trust, but I kind of wanted to break them down a little bit further for you today. So just to educate you guys a little bit more about what you will be getting with an estate plan. So there are 3, sometimes 4 documents in a basic estate plan. That would be your will, your power of attorney, a medical power of attorney, and for some people a trust. So let's just break these down. A will basically just tells people and directs an individual known as the executor to basically just accumulate all the assets, pay off your debts and creditors, and pay out to my beneficiaries. That's really what it says. It's not saying anything more than basically go do that, go get my money, pay off my people, and hand out everything to my beneficiaries, who I've basically outlined who they are and what each person's going to get. Clean, simple, pretty easy. The executor has their own job. I'll get into that in a later video about what the duties of an executor are, but that's basically what a will is going to do. There are 2 really major important documents that you need in your estate plan while you're living. A will is when you're deceased, and then we have these two documents on the other side while you're living that are majorly important. These would be your power of attorney and your medical power of attorney. So what does a regular power of attorney do? A regular power of attorney basically just states, hey, when I'm incapacitated, this individual will step in to handle my day-to-day affairs. They're going to pay my bills, pay my mortgage. They are going to ensure that my children are taken care of if I have minor children, sign permission slips, stuff like that. On the flip side, a medical power of attorney basically protects you when you are incapacitated in the hospital, and this person is you've basically directed an individual to make medical decisions for you. Now, why is this important? Why are these 2 forms really important? Well, number 1, if you don't have a power of attorney and you're incapacitated, now the court system moves super slowly. So you'd have to file a petition with the court to gain guardianship. This is going to be super costly, super time consuming, and it's a waste of time when you could have spent 15 minutes, an hour, 2 hours with your attorney to figure out who's the person I want to put in charge. Also, as we know, health moves a lot quicker than the court systems do. On the flip side, with the medical power of attorney, if you don't have a medical power of attorney, you're going through the same kind of issue. And let's face it, when there's a medical crisis, things are moving super quickly. And if you don't have a point person that doctors can talk to, who can make life-saving decisions or these decisions, your family's not going to get this information because the hospitals have to operate under HIPAA. And they need to know who this point person is. So again, you're going to go through the court system that takes so long when you could have sat down with an attorney and figured out during this time, this is who I want my medical power of attorney to be. This is the person I'm going to make that's going to make my decisions for me when I cannot make a decision. Another thing we have to think about too is, God forbid, you and your wife or you and your spouse are going to travel abroad. Not like we can travel abroad these days anyway, but that's beside the point. And your something happens, your plane crashes, you're seriously hurt. Your power of attorney you need a guardianship plan basically as well, and this is more for people with minor children. It's called a minor power of attorney, where this person would step in and basically be the guardian of the child or children until you are back on your feet and able to resume your parenting duties. That is something we do like to set up with people who have young children, just because it is an ease of mind. Because remember, the guardian in your will does not take over until the will's been probated, which is 10 days after your passing. So this is just something else you need to remember as well. The last document it's going to depend is a revocable living trust. Basically what these do is envision like a portable container. Basically what the trust is, you take your assets, you put them in this container, you're directing to an individual to say, look, you're in charge of this money, you're in charge of the assets, this is how you generate income off the assets, and the person that is to receive that income, here's how they can claim this income. They have to file a written request with the person in charge. It could be a quarterly disbursement. It's all based on how you draft it. It's pretty simple, clear-cut, easy to do. But mainly, we set up trust because God forbid we pass and our children are minors. Somebody gets to watch over that money, but at the age of 18, the child gets that money uninhibited, unrestricted, and just like the movies have shown us, when you are an 18-year-old or a young person who receives a ton of money or a ton of property, it's spent frivolously and recklessly, and it's gone really quick. And we're just trying to protect everything and everyone, and we want our children to have a better future, and that's why you create that kind of trust as well. So just to recap, we've gone over a will. Will's basically for post-life, and it's directions on how to distribute your estate. Then we have during life, we have our power of attorney and our medical power of attorney. We also have what's known as a minor power of attorney for children under the age of 18. And then lastly, we also have the revocable living trust. As always, my name's David Campanile. I'm the owner of Campanile Law here in New Jersey. If you want to talk estate planning with me, right down in the description, you can reach out to me at njestateattorney.com. I do this all day, every day. I love to chat about this stuff, and have a great one.